the fact that several of you have submitted questions which the first intended panel were not able to answer because of our tight schedule. I'll try to summarize and reduce my paper sufficiently so that there'll be ample opportunity later on in our program that some of the questions posed by you can be answered by the next panel. The Provincial Court Civil Division was established under the Provincial Court Civil Division Project Act as a test project, quote, for the development of simplified procedures and methods of making civil remedies more accessible and reducing delays. As you know and as you've heard this morning, the jurisdiction of the Provincial Court Civil Division is the same as that of the Small Claims Court, except that the maximum monetary jurisdiction of $1,000 set out under Section 55 of the Small Claim Courts Act is $3,000 in each instance. You're also aware, and I think you'll be told later on, that the provisions of the Small Claim Courts Act apply to proceedings in the Provincial Court Civil Division. This is set out under Section 6, subsection 2 of the Provincial Court Civil Division Act, except insofar as they are inconsistent. So you should pay particular attention to Section 2 of the rules of the Provincial Court Civil Division, Revised Regulations of Ontario 1980, Regulation 806, because Section 2 of the rules indicate the section of the Small Claim Courts Act and rules of procedure which do not apply in the Provincial Court Civil Division. Now, in terms of pretrial conferences, you will be normally notified by the trial coordinator that you are to attend a pretrial conference. You are normally given sufficient notice to permit a thorough preparation. The purpose of the conference is to attempt to simplify the issues, obtain admissions which will shorten the trial, reach agreement on items of damage, and explore settlement. If settlement is not reached and does not seem possible, attempts are made to estimate the length of trial and fix trial dates. These conferences can be extremely useful settlement procedures and in practice result in settlement of very many cases. A pretrial conference can be of particular advantage to younger counsel as they receive an impartial assessment of the claim from a trial judge and are in a position to discuss any settlement proposal with the clients on the basis of opinions expressed by experienced trial judges. You will frequently find clients much more amenable to settlement if they know the case has been thoroughly considered by a judge in addition to their own lawyer. Now, Rules 48, 49, and 50, of course, of the rules of the Provincial Court deal with pretrial procedures, and I won't go over them because you've got them in the paper. It should be noted that the judge who conducts the pretrial conference shall not thereafter hear the action unless the parties consent in writing. However, this does not preclude a judge before whom a case has been called for trial from holding a pretrial conference without disqualifying himself from trying the action. The objects of pretrials, as I've mentioned, are the promotion of settlement, the shortening of trial time by the clarification and reduction of issues and the limiting of witnesses, and also the inevitable improvement of the quality of the trial by helping increase the preparedness of counsel. The object of the pretrial judge in our setting is not to urge or coerce settlement, but to encourage the exploration of compromise. Proper conduct and, most importantly, preparation for the pretrial conference should reveal the strength and weaknesses of this case, or the case. Quote, "I just got the file last night," unquote, is absolutely inexcusable and a waste of time. Again, we must keep in mind not only the unrepresented litigant, but the represented litigant. For example, in some cases, the worth of a counterclaim is often similar to the cost of filing it. The pretrial procedure, when properly conducted, will inevitably improve the quality of the trial. Inexperienced counsel, articling students sometimes need to be directed to what are the proper issues and the kind of evidence required in support of same. Experienced or not, I have found that articling students always come to pretrial hearings prepared. I would support pre-trying as many cases as possible, particularly those where general damages are sought, and of course those where perhaps one side is unrepresented. All actions in the Provincial Court Civil Division are not automatically pre-tried. The initiative must often come from the bar, and also, of course, our own judges review the files that will eventually be heard in our court. Counsel should be prepared to intellectually discuss the issues. If counsel are not adequately prepared, then the pretrial becomes a perfunctory and relatively useless exercise. It is a waste of everyone's time if someone is sent to the pretrial hearing who has little or no knowledge of the case and no authority to make admissions or recommend settlement. Pleadings must be reviewed to ascertain what matters can be agreed upon. If it appears that amendments are required, then these can be recommended at the pretrial hearing. And I would direct you in particular to Rules 59 and Rule 61 of the Rules of the Provincial Court Civil Division. We must not assume that the more complex the process, the more refined and deliberate the procedure, the better the quality of justice that results. Equity looks on that as done which ought to be done. Equity looks to the intent rather than the form. Rules 51, 52, and 53 deal with trials, witnesses, and evidence. I would refer you in particular to Section 2 of the Provincial Court Civil Division Project Act and Rule 3 of Regulation 806. When preparing for trial, keep in mind the objective of this court: to secure an inexpensive, expeditious, and just determination of every proceeding before it. The scope of the evidence to be led at trial would generally be governed by the pleadings and any memorandum of agreement, which is very useful, which may be prepared at a pre-trial. You must therefore review your pleadings before the trial to ensure that the pleadings accurately state the facts which need to be proven in support of your client's position. I might also add that, of course, counsel from time to time quite often referred to a specific paragraph in a claim that's been prepared. Needless to say, most litigants never see and never read the claim. It might be useful sometimes to read a claim before filing it with your client so he'll know what he's pleading. What about the question of motions at trial? As a general statement, you should try to avoid motions at the beginning or at the opening of trial. If the matter is at all contentious, you will probably be met with a demand for an adjournment and run the risk of having to pay the costs of the day. If the matter is not contentious and the trial judge grants it, it creates a bad impression before a court and suggests that counsel has not been particularly careful in preparing his case. You will find some trial judges who are most unhappy about motions at the opening of trial to amend pleadings. They take the view, quite properly, that these are matters which should have been straightened away well before trial, and they should not have to waste court time in clerical matters. It can be upsetting if you have the experience of running into a trial judge who has no hesitation in commenting on the fact that what you are seeking is something which should have been done weeks before. And with respect, of course, to motions before trial, counsel appearing at trial should not swear the affidavit to be used. He cannot or she cannot be a witness and a counsel in the same manner. If you have witnesses who have difficulty in either speaking or understanding English or the English language, it may be advisable to have his or her evidence introduced through an interpreter. And this does not necessarily mean a brother, a sister, a mother, or a father. The use of an interpreter is a matter, of course, in the discretion of the trial judge, but the trial judge will invariably permit the use of an interpreter on representation of counsel that such is necessary. Whenever possible, the services of an expert or independent interpreter should be obtained. The provisions with respecting trials, witnesses, and evidence, as I mentioned before in the Provincial Court Civil Division, are substantially the same as those in the Small Claims Court. In the Provincial Court, the evidence by or on behalf of the plaintiff may be given by affidavit, unless in a particular case the trial judge requires the plaintiff to call oral evidence. There is also provision for serving all opposing parties at least 20 days before the date fixed for trial with copies of all documents and signed written statements of any witnesses. This is set out, of course, in Rule 53. Query the failure to abide by the times prescribed. And I would refer you, of course, to Rule 3, as well, of course, as to Rule 4 and Rule 7 of our rules. And particularly Rule 4, which deals with a procedural defect to be treated as an irregularity rather than a nullity. And Rule 7, of course, which states the court at any time may lengthen or shorten a period of time prescribed by these rules or prescribed by any order of the court, upon such terms as the court considers proper in the circumstances. The question of adjournments has been canvassed by speakers before myself. There is no particular rule of our court dealing with adjournments. There is a practice note dated March 4th, 1983. It is, however, the court, not the lawyer, seeking the adjournment of the trial, which will usually be blamed for delay. Most litigants want their cases dealt with quickly. Counsel should be aware that appellate courts will usually not interfere with the discretionary power at the trial of the trial judge to refuse an adjournment. And for that reason, adjournments should not be sought merely to accommodate or merely to convenience counsel with busy schedules, particularly where the other side is prepared and ready to proceed. Some trial judges will not grant adjournments even where both parties request them. We must not be seen to accommodate counsel at the expense of their clients. If you do not have to seek an adjournment, or you do have to seek an adjournment, you must advise your opponent as soon as you know your position. You must also let the court know. It's intolerable where there is, for instance, a one-day trial scheduled. No other cases are scheduled to be heard that day, and no one shows up. Such abuse may ultimately result in these cases always being made peremptory. Thus, the flexibility one may enjoy at the present time may be lost in the future. Somewhat related to adjournments, of course, as I mentioned, is the matter of interpreters. And if it is a matter that you feel needs an interpreter, you should have the interpreter in court. And again, presumably not necessarily a relative, so the matter can proceed on that particular day. I won't spend much time going over Rule 44, dealing with costs and double costs, because that's been canvassed by several of the judges. Costs in the Provincial Court Civil Division, as I mentioned on page 17, are limited to the fees provided by the tariffs and the schedules and the rules, a counsel fee, and a few incidental cost provisions. Where an action is for more than $1,000, a counsel fee up to $300 can be awarded. Where the action is for $1,000 or less, the counsel fee is limited to $40, except that where the trial takes more than one day, the maximum is $50. Other rules dealing with costs are Rules 2, as I've said on page 17, 20, 47, 54, 55, 58, and 64. Our objective is more elusive than the quest for speed. Obviously, we are after justice. Justice which includes both speed and fairness. Fairness of judicial procedure presupposes at a minimum a system operated according to legally prescribed rules which are routinely applied to those who come before the courts. We must inquire as to what do substantive law and justice require, not necessarily whether the rules of the game have been strictly followed. The Provincial Court Civil Division has been a positive response, in my opinion, to what Roscoe Pound referred to in his famous 1906 speech to the American Bar Association on the causes of popular dissatisfaction with the administration of justice. We may look forward to a near future when our courts will be swift and certain agents of justice whose decisions will be acquiesced in and respected by all. Thank you.
Thank you, Judge Zuker. It's now my pleasant duty to introduce some of the panelists who will be dealing, hopefully, with the questions and who have some important matters to deal with in relation to certain topic areas. In order to make sure that we have some representation from out of town, and I had the fortunate opportunity to meet a number of solicitors and other people who are here from out of town who are interested in what's happening in this court because they know that the civil division will be extended outside Toronto and they're interested in what happens in the small claims courts from the point of view of the judges. We have the opportunity of having Judge Charlie Tierney with us, who operates from the court in Ottawa. He graduated from the University of Ottawa and articled there with a fine firm, and spent his years in practice with the firm of Hewitt, Nesbitt, Reed, McDonald, and Tierney, and he practiced in the area of insurance law. And that, as you know, is a very, very tough area to deal in, and we get a lot of problems in our courts related to those areas, motor vehicles, etc., and that assisted him very much, as I understand it, in his years on the bench. And he was appointed to the Small Claims Court in 1978, and he tends to spend part of his time commuting down to Toronto to help us out when we get into trouble, or when we need a judge, or when we just simply need advice, because we find that in his quiet way, he really knows what's going on when we don't know what's going on. To the man who knows what's going on, Judge Charlie Tierney.
Sure. I'll get you some water.
Good morning. I'm your judge from the county town, in this case from Ottawa. Most people in Toronto think that Ottawa's greatest contribution is in the acquisition of Bob Wabilovich. Thanks very much. Now, the paper that I wrote up for this seminar, entitled The Procedure in the Provincial Court Civil Division versus the Small Claims Court, a comparative analysis, is intended to point up some of the variations in procedure as between the two courts and also some of the similarities. It is by no means exhaustive in its approach, and it was not so intended. It's simply meant to outline, by way of a general approach, to the proceedings in the two courts, which for the moment, and probably for the foreseeable future at least, will coexist until the Provincial Court Civil Division goes province-wide, if and when that should come about. No doubt we'll hear more on that matter from one of the speakers to follow. One of the topics which I've dealt with, the transfer of actions. In Metro Toronto, the Provincial Court Civil Division has concurrent jurisdiction with the County Court to deal with actions in the range of $1 to $3,000. Outside of Metropolitan Toronto, the small claims courts have concurrent jurisdiction with the County Court to deal with actions in the $1 to $1,000 range. Section 11 of the Provincial Court Civil Division Act sets out provision for transfer of actions where the amount claimed is over $1,000 to the appropriate county court in those situations where actions commenced in the Provincial Court Civil Division ought to have been brought elsewhere because the guidelines for jurisdiction as set out in Section 64 of the Act have not been met. Provides that the action shall not fail for want of jurisdiction but may be transferred, and the order is obtained from a judge of the Provincial Court Civil Division. By subsection 2 of the same section, where the claim is in the under $1,000 category, Section 70 applies and the action may be transferred to any court having jurisdiction. Now, by a combination of Section 7, subsection 2 of the Provincial Court Civil Division Act and Rule 62, an action which was commenced in the Supreme Court of Ontario or in the County Court prior to June the 30th, 1980, may be transferred to the Provincial Court Civil Division on consent of the parties. Again, it's not an absolute right, it has to be done on consent. Now, there is an oversight in my paper on this particular aspect. It occurs on page 3, and it is this. While it is true that Section 62 of the Small Claims Courts Act was not specifically carried forward to the Provincial Court Civil Division Act by Rule 12, the same provision came in by the back door, so to speak. So if you care to look at Rule 12, it says, if it appears to a judge of the Supreme Court or a judge of the county court that an action is one which ought to be tried in the Supreme Court or a county court, he may order that it be transferred to the Supreme Court or to a county court, as the case may be, upon such terms as to the payment of costs or otherwise as the judge thinks fit. So, whereas by the old Section 62, the order could be made by a justice of the Supreme Court of Ontario, now it can still be made by a justice of the Supreme Court of Ontario, but also by a judge of the county court. So my apologies for that oversight. Dealing with third-party claims. To the extent that the procedure provided by Rule 36 permits a claim other than one based in indemnity, it represents a departure from the standard third-party procedure as set out in the Small Claims Courts Act and also the rules of practice of the Supreme Court of Ontario. One might speculate on the scope of this section. For instance, an action is brought by a consumer against the retailer of a defective product, the typical Donahue-Stevenson situation. The claim is being sued in tort, and the retailer third party is the manufacturer, that claim being a claim for indemnity based in contract. The wording of the section certainly leaves little doubt that such a claim is covered by the section. However, it appears to go farther than that. It appears to be broad enough to also permit the retailer to claim that he suffered a loss of clientele as a result of the bad publicity stemming from the incident. On the subject of amendments, in both courts, the Provincial Court Civil Division and the Small Claims Court, broad powers of amendment are granted dealing with adding and substituting parties and amendments to pleadings. So as counsel, you must be on guard that as a result of these powers, it may be that the case you have to meet is somewhat different from the one raised in the pleadings. And if you have any doubts about it, a good place to have those doubts resolved is at a pretrial conference. And as you're aware, a pretrial conference can be requested by counsel or it may be directed by the court. The general principles of construction are set out in Rules 3 and 4, as earlier speakers have noted. There is to be a liberal construction of the rules, and the result of failure to comply with the rules is deemed to be an irregularity. All necessary amendments or other relief may be granted on terms to secure the just determination of the real matters in dispute. Rule 61 of the Provincial Court Civil Division Act, dealing with the power to strike out or amend scandalous, frivolous, or vexatious pleadings, has no counterpart in the Small Claims Courts Act. That's unfortunate, I think, because there are some actions which have obviously no legal foundation, and yet technically the court cannot dismiss that action on an interlocutory motion and must hear the evidence. I think that that's just one further indication of the need to revamp the rules of the small claims court. And another indication of such need appears when one considers the subject of motions. Motions is a topic that's going to be dealt with in a few moments by Judge Lamb, and I simply wish to say that it is something which is specifically provided for in the Provincial Court Civil Division Act by Rule 45. However, in the Small Claims Courts Act, it has no specific authorization. And yet, by reference to the broad variety of orders which the court may make pursuant to the Small Claims Courts Act, it is quite clear that motions are contemplated. Prior to 1977, the Small Claims Courts Act had Section 190, which allowed the court to rely on the provisions of the rules of practice if there was no specific provision in the Act. However, the section was repealed in that year, and so there is a sort of hiatus which has developed as a result, because suddenly you find there are many situations where there is no specific provision for relief, and yet it's obvious that the relief ought to be granted. And finally, on the subject of payment into court, which I've dealt with at page 14 and 15 of the paper, I wish to advise you that there's been an amendment to Rule 806 of the revised regulations of Ontario 1980 under the Provincial Court Civil Division Act. It's Ontario Regulation 239 of 83. It's an amendment to Rule 43, subsection 5 of the Act, and it is included in the material which you were provided this morning. That deals with the situation where there has been a payment into court and the plaintiff recovers less. The old provision, on my reading of it in any event, would indicate that all of the monies paid into court are to be paid out to the plaintiff. And yet it may be that because of the mathematics, the defendant paying the money in may clearly assert a right to the payment out of the amount of the excess to him. I think it is this situation or gap in subsection 5 to which the amendment refers and corrects. That concludes my brief remarks this time. Thank you.
I told you that he's got a sixth sense. This may be an appropriate time to mention that the numbering in the pages that you have is a little different than the numbering that's in the pages that the people speaking have. They only have the numbers that they originally put in to their material, and the Law Society has renumbered them in consecutive order. So you'll have to notice that in the table of contents, and I'm sure you've caught that by now. The judges, of course, were all in private practice, and we've all had our problems. And the judge, who I'm going to introduce now, told me about the client that he had worked on and spent a great deal of time and trouble and patience and hard work, and he finally got a settlement. And when he called the client to tell him he's got a settlement that's fair to both sides, the client's reaction was, fair to both sides? I don't need a lawyer for that. I could do that myself. Anyway, the judge that was telling me about this was in private practice, and he is what we would call a model judge. He also happened to go to the Toronto Model School, which was, in case you don't know it, a school that was considered the epitome of education at the time, back when he and I were young, Maggie. And he then subsequently went to the University of Toronto to get his law school degree, and he practiced in the area of general corporation, commercial law, and labor relations with the firm of Dillout and Cronin, and where, because of his good works, he managed to force them to become a partner in 1958. In 1968, he became a Queen's Counsel. He also has the distinction of having been in the Royal Canadian Naval Reserve. And for those of you who would like to have been out skiing today, as some of us, depending on the weather, he happened to have been the incorporating counsel for the Canadian Ski Patrol System and their general counsel for a number of years, and so we have him to thank for the fact that they can't be sued. And then he was appointed to the Provincial Court Civil Division in November 1981, Judge Lamb.
Waistline will attest I need all the standing I can get. Is it working?
Is it working?
Okay. It's always a danger when you hand in a curriculum vitae or whatever that they'll always pick the thing you don't expect. You never know where to start, so you always start at the beginning, and I guess I started at, quotes, the model school, and that's how it came out. As we have all been instructed in connection with this seminar today, that we are not to read our papers. And of course, I always follow instructions, so I have no intention of reading the material which I supplied, and it's precious little, as you'll probably notice. I tried to sort of collect the various areas in which motions appear to be necessary or relevant, and I'm sure you all study those categories with great interest. And I will refrain from adopting the position that was done by the late Mr. Justice Walsh. And those of you who are old enough to remember the late Mr. Justice Walsh will know that there were many stories that could be told about him. Perhaps someday somebody will make up an anthology about Mr. Justice George Theophilus Walsh, but in any event, there was a story told that he was in the Court of Appeal one day, and there was a 3-judge panel, and he was reading extensively from a transcript. And one of the judges interrupted him and said, "Now, Mr. Walsh, you can rest assured that we will be reading all that material." Well, Mr. Justice Walsh at the time, and for many years, was a peppery little individual. He always used to come back, yes, my lord, I know you're going to do that." And he turned to the other justice on appeal who was sitting there. He said, "And you, my lord, are you going to read this all very carefully too?" And the other judge said, "Oh, yes, Mr. Walsh, I'm going to read this transcript very carefully." And he turned to the third justice on appeal, and he said, "And you, Mr. Justice so-and-so, are you going to read this very carefully too?" And the other justice says, "Oh, yes, Mr. Walsh, I fully intend to read every word." Then Mr. Justice Walsh, or George Walsh, as he then was, says, "Well, that's just wonderful. Let's all read it together." Now, he was never daunted, as any of you who will remember him, by anything that the judges say. I'm afraid that I personally have some difficulty with comebacks from some of the comments and the questions that are put to me, as I'm sure many of my fellow judges do as well. Now, in connection with motions, I just have a few points that I want to mention outside of the written material. And they have been touched on. It's almost impossible to avoid a little bit of overlap in this kind of a panel because we are trying to cover various areas, but they inevitably intermingle. And my first point that I've got that I really want to mention is that, as we've said, many of the fix-up motions, as I call them, could be avoided by careful searches of company, partnership registration, proprietary registrations, etc. And I remember on at least one occasion in my practice making the mistake of relying on the information which is provided by your client. And that can often be expensive. You have to do and have to make some investigations on your own, if it's no more than putting the question very forcibly to your client, do you really know the name of this company? Have you seen a purchase order? Have you seen a letterhead? Have you seen something that might make sure that the cause of style of cause is correct? Secondly, in connection with the affidavit material on a motion, a lot of this stuff is common sense, and one almost apologizes for having to bring it up. But the affidavit material should really have enough information. Now, with unrepresented litigants, the affidavits are pretty sparse, and usually on where they are motions to set aside, the affidavit might say, I marked the wrong court day, or I didn't come, or something of that sort. But it's certainly where there are agents or students or lawyers involved, there's no reason why there can't be adequate information set out in the affidavit. Not long and drawn out, but something that the judge can work on in connection with his consideration of the motion itself. The third thing I've got down is be prepared to deal with the possibility that the relief which you are requesting will be granted by the judge hearing the motion, but there may be some terms. And I think a lot of times that counsel and students alike are sort of unprepared. They think it's always going to be a yes or no situation. And this is one of the areas, particularly in our court, which we feel often should be utilized. It may be an order for not only costs, but perhaps a substantial portion of the claim into court to abide the trial. Those situations do come up, and as counsel and students, you should be prepared to consider the fact that maybe the judge will order, something that you didn't really expect in order to grant the relief that you're looking for. Judges are noted, of course, for saying things that you never expect. Item 4 that I've got is where, and there are applications to set aside judgments in default of defense. Make sure that you file a draft defense on the motion. That'll give the judge an idea as to perhaps the merits of the defense without all the nitty-gritty of the defense itself. But very often, as I say, the material filed merely pertains to the question of default and not whether or not there is a reasonable defense and some indication of where that defense might be going. There again, unrepresented litigants, we do have to face the problems that they are not, with the fact that they are not exactly conversant with a lot of these procedures. You may notice, particularly at the end of the material which I provided, some proposals in connection with the dispositions of motions before trial. Now, I stress that these are proposals in the sense that we are looking at them from the standpoint of our bench. We are doing what we can with the clerks to see whether or not the ideas that we are putting forth will work so far as their arrangements are concerned and things of that sort. However, one of the proposals which is included is a suggestion with respect to motions days. And the intent now is, if you're not already aware, is that there will be motions days in the months of March, April, and May. The present anticipation is that each judge involved in that program will deal with 40 motions on that day, 20 that will be set down for 9:30 and 20 for about 11 a.m. So if you are involved in the motion day program, if I can call it that, you will know what I mean. But so far as the other procedures are concerned, and it provides perhaps an indication as to what happens under the present program, but it also includes some of the things that we're trying to accomplish. And may I at this time, if there are any members of the profession, students or clerks or otherwise, who have some input in connection with those proposals, don't hesitate to drop a memo to the senior judge, and we will certainly be happy to consider whether or not our ideas appear to be feasible, or whether or not there should be some changes even in the proposals. A lot of the fix-ups, as I say, that come by way of motion probably shouldn't be necessary. I have only one other comment, and it's been touched. It was a saw with me for the 28 years that I was in practice. It used to, the boilerplate, everybody talks about it, nobody does anything about it, but the amount of boilerplate that comes up in pleadings, particularly in motor vehicle negligence cases, you know, allocations of affluence of alcohol and all that sort of thing, where there isn't a shred of evidence, but down it all goes, you know, under the influence of alcohol or some other drug, and you almost feel like penalizing somebody 5 points for everybody who puts down that in the claim, and they haven't the slightest idea of proving it. And I recall on one day going through and sort of ticking all the things that were completely irrelevant to the case at bar. So I really think we have to be careful in that area. Hopefully the new rules of practice will do something. The pleadings were supposed to define the issues. In all my years of practice, I found that they merely disguised the issues. And I just hope there were areas where there should be definitely some improvement. Obviously, nobody wants to leave any turn unstoned, but there's no sense putting a whole lot of garbage in that you may have to later take out or amend or change or all the rest of it. My last comment is this, that, as you know, subject to the motions days, which is a new departure, we have very limited time to hear motions. Normally motions are returnable at 9:15. With court opening at 10, it gives us a maximum of 3/4 of an hour. And most judges like to have at least 10 minutes breathing space between having to deal with motions and having to face the opening of court. So if you have motions which involve some complicated problems, and we do get them, mention that to the clerk so he doesn't load up the list with other motions as well. And I recall, for example, even as recently as yesterday, His Honor Judge Tierney has mentioned some of the out-of-town procedures, but there was a motion which he ended up dealing with, where there was in a sense an agreement that now let me get this straight, that the case or the under 2000. Oh, wait a minute, let me get this right. There was an action brought, and I think it was by one of the card companies to claim an account, Visa or American Express or somebody. There was a defense and a third-party claim. And there was a motion that proceedings in the main action be stayed pending an application to transfer the matter to the small claims court in St. Catharines on the question of liability in the third-party action, and also an apparent agreement between counsel that they would be bound by the decision of the small claims court in St. Catharines, even though the amount which was in dispute, or the relief claimed, was in excess of the jurisdiction of that court. Now, that's a very interesting motion, and there are perhaps a lot of things to be said and a lot of arguments to be made. But please, if you have those kind of things, those kind of motions, make sure that the clerk knows so that perhaps that is the only motion set down for that date. As it happened yesterday, that was the one motion that had to be dealt with. But do keep that in mind, and because the motions, I think, the motions are inevitable. They're not always fix-ups. They are things that come up and should be dealt with by way of motion. But some of them do require a little bit of thought, and where there are 3 or 4 motions set down, you don't get much time to deal with individual motions. So just allow enough time where you've got those kind of that kind of consideration. Thank you very much.
As you can see, Judge Lamb has that effervescent personality, and he's always getting his words twisted. The problem with Judge Lamb is that he won't let us say anything laudatory about him, so that it's very difficult to do it. What he does is he lightens our day with wise sayings whenever we get into trouble. And that probably came through a little bit in the presentation today. At this stage, I'd like to deal with questions. We have a number that were put in the box. And because Judge Zuker was kind enough to cut his portion of the presentation short, perhaps he might like to come up and help us field some of the questions. There's only room for one more chair up here.